Good morning. This is Bashir Fancy. I'm one of the founders and president at BIZTEK Professional Association of Canada, BTPAC. We're part of ICCP that has been around for 50 plus years. We're all about education, certification, code of ethics, making sure that everybody keeps their skills and knowledge relevant and current in both sides of the fence so that business people understand technology in order to be able to program, but at least you need to understand. And technology people understand the business, otherwise they cannot do justice. So today, as I've already told you about BIZTEK, PTPAC, ICCP, and feel free to join us. There are no fees for the next year, and hopefully we will make that permanent by sending your information to join at btpac.org, or you can subscribe to each webinar. We recommend you join since there's no fees at the moment, and more importantly, we'll keep you informed. If you want any information about us, you can get it at info@btpac.org, and before too long, we will also have the website up, but you can look at what the courses and certifications are by going to iccp.org. So it's ICCP, you can see it, .org, and you'll get the same information. And I want to also thank Samba Live, whose technology we're using today in terms of broadcasting this. They have been a fabulous partner. And now I'm very pleased to basically present Derek Lackey, who's going to speak to you about GDPR. And Derek, who's one of the board advisors for us, and has been a partner with us in many different ways, actually is a very knowledgeable and experienced person in that he has been running an ad agency for 30 plus years. He's the chairman of Response Marketing Association. He's also the managing director of Newport Thompson, and he chairs the working group on guidance of Canadian Advisory Council on GDPR, which is the subject he's going to be talking about shortly. If you heard him on Friday, he talked about CASL. He is also a member of the ISO 31700 Privacy by Design for Consumer Products, and also a member of Canadian Data Governance Stabilization Collaborative Effort, SCC. He's actually got a lot more background, and you'll be impressed when you see all the others. He's also an author of the CASL Compliance, a marketing's guide to the email marketing of Canadians. He's a CPIM, which is Certified Information Privacy Manager, and co-chairs IAPP Knowledge Net for the Toronto. We'll go to his presentation straight.
Good morning, Bashir. Thank you for having me today to talk about GDPR at a fairly high level. So what we're going to look at this morning is what are the requirements around compliance for GDPR, and we can start with that if you're doing business in the EU, you must be compliant with GDPR. And let me broaden that a little bit. There are two fundamental positions you can take. You can be a data controller, or you can be a data processor. And regardless of which one you select for yourself for that particular activity, you must be compliant with GDPR. So if you're a North American data processor located, let's say here in Canada, and you are processing EU personal data for a EU company, you must comply with GDPR. So it's a little more far-reaching than many people believe. So it's all about the capture and management and processing of individuals' data, and e-privacy is all about communication. So you may not be familiar with the e-privacy. It's currently a directive and is going through Parliament now to become a regulation with proper enforcement. And it's the communication side. So while GDPR is about the management and processing of your data, the e-privacy is about all of your communication um, in the EU and UK. So my name is Derek Lackey. I'm the managing director of Newport Thompson and also the chairman of the Response Marketing Association. I sit on several global councils on GDPR, privacy by design, and even on cybersecurity. I've written a book on council compliance called The Marketer's Guide to Email Marketing to Canadians. I'm a certified information privacy manager from the IAPP, and I also am their co-chair for the IAPP Knowledge Net in Toronto for the next 2 years. So as a general overview, GDPR requires a completely different mindset. So prior to GDPR coming in to force in May 2018, yeah. Prior to that, the context for capturing and processing data on an individual was, it's my data, and this is from the company's point of view. The position was, it's my data and I'll do whatever I want with it. The new mindset is, it's their data and you must have consent to do what you would like to do with it. That's a completely different contextual conversation around data, and that's the fundamental change that the General Data Protection Regulation brought in. The EU basically took the position that you are not the owner of the data, you are merely a custodian, and you require permission or consent to do many of the things that you just took for granted and did prior to this law coming in. So that's the first mindset shift that you need to have when you're thinking about GDPR. The next one, before I can answer any questions you might have about GDPR, in the example you're trying to solve, you must decide, are you the data processor or are you the data controller? And I'll tell you, just in plain English, the data controller is the one who decides what's done with the data. The data processor is the person doing it. So a data controller is the company who collects the data and decides what they're going to do with it, and then they hire or contract data processors of various kinds to do something with that data. So what I mean by each situation is when I'm dealing with sending emails, for example, I have to decide, am I the data controller? Do I decide who gets the emails and what they get? Versus MailChimp, who is the data processor. And believe me, both are now accountable. So it used to be the data processor could just point the finger at the data controller and say, it's, you know, the breach or whatever happened, it was their fault. Now both are held accountable. The GDPR has allowed for data processors to be fined for their role in any kind of breach or misuse of data. So in that context, given what I just said, for some organizations, data may well move from being an asset to being a liability based on how it's captured, stored, and processed. So, you know, companies who keep data forever, they don't like GDPR. GDPR really requires that you have a purpose limitation as well as how long you're going to keep the data. That's actually part of the disclosure you need to give to the people you hold data on. So I'm sure there's an updated privacy overview from data guidance. I looked for it yesterday and could not locate the new one, but this gives you a good sense of kind of there's changes going on all around the world in privacy and data protection and cybersecurity. The current thinking on cybersecurity is not if you're going to get hacked, it's when you're going to get hacked. And I think it's the same with privacy. And quite frankly, all of these new laws dictate that you must take reasonable precautions to secure any data that you capture and use. And so we talked a bit about this. For every situation regarding data, you must ask yourself, am I the controller or the processor? And sometimes that changes. So within the context of capturing and using people's data, you may flip between being the controller or the processor. There's some processing you may do yourself, such as profiling or internal algorithms that you use to put people in buckets or profile people. Those are all things that you may control yourself, and therefore you become the controller and the processor. There are also situations where you are a co-controller or a co-processor. And so you just have to, in each case that you're considering data, you have to consider, am I the controller or the processor? And that's the very first level question you need to ask. The next one is, what is my lawful basis for processing personal data? So under GDPR, there are 6. We will go over them later in the presentation, but there are 6 you can choose from. And really, as a private business, there are 3 that you can choose from. The other 3 are really meant for law enforcement and government agencies. Consent. Many people think that GDPR is all about consent, and it's not as much about consent as understanding your permissions. Your business has reviewed how you seek and record and manage consent, and your business has reviewed the systems currently used to record consent. One of the things you have to understand is that of the and we'll talk more about this in the lawful basis, but consent would be my last one to choose. There are a couple of others that you would choose first, but the important thing at this stage when we're talking about consent is it's not what you have, it's what you can prove. And that's a big distinction. We run into this under CASL here in Canada as well, is a lot of people go, well, I have consent. And I go, that doesn't count for a hill of beans, because unless you can prove consent, when CRTC comes in to fine you, or in the EU's case, the Data Protection Authority comes in to investigate you, if you can't prove it, it doesn't exist. This is what I was talking about earlier. There's a data minimization factor. Only collect what you need to do business. Only keep it as long as it's required. And under GDPR, your data should be clean, current, and permission-based. Now, there is no hard and fast rule, but the legal people are saying that your permissions and your data shouldn't be any more than 2 years old under GDPR. This is a big part of the legislation, was to protect children. And if your business offers services directly to children and you communicate privacy information in a very clear, plain way that a child will understand, in other words, your language around what you do with the data has to match the audience that you're talking to. So if you're talking to 6-year-old children, you actually need to 6-year-old child would understand it. If your business offers, if your business has information society services directly to your children, your business has systems in place to verify that you know their age. So you cannot be offering services to children and without having a record of their age as you're dealing with them. Data transfer is again another big cornerstone of GDPR. You cannot transfer data over borders without the proper framework. So there's a couple of frameworks that exist. The Privacy Shield is the main one for the US. It replaced Safe Harbor, which was deemed inadequate by the EU Council when they were implementing GDPR. So if you're exchanging data, if you're crossing the border into the US, you need to do so under the Privacy Shield, which is a set of framework and a set of practices that is designed to protect EU citizens' data while it's in the US. Canada and a handful of other countries have what's called adequacy, which means that our federal policies are, in Canada's case, it's PIPEDA or PIPEDA. It is safe enough or high enough bar that the EU has deemed it that we're adequate for managing EU data. So you're free to transfer data back and forth from Canada to the EU and vice versa, but not from the US. If in the US, you must do it under the Privacy Shield. It's a whole bunch of things like the Patriot Act makes the EU nervous about EU data being shared across the US borders in any method other than the Privacy Shield. That's a big deal and a lot of fines coming from it. Third-party agreements also are one of the big changes. So as I mentioned earlier, processors are now being held to task for their role in a breach or a misuse of data as much as the controller. So you're going to see that the fines coming out are a mix of fines to the data controller, and sometimes it'll be both. They'll deem that both the controller and the processor, because you didn't have a third-party agreement in place that respects GDPR and all of its nuances, that the controller may be held responsible and both may be fined. As in many other countries, data breach reporting protocol is mandated under GDPR. So when a data breach occurs, there are obligations and expectations to the DPA in the EU, depending on which country you're in. You must report, once you know about a data breach, you must report it to the DPA within 72 hours of knowing about it. That becomes a whole standard. Like even in Canada, it's a reason, within a reasonable period of time. But in under GDPR, it's 72 hours. So they're really cracking down on the reporting of data breaches. One of the vulnerable areas, I think, for most companies is the websites and web forms. So your public-facing data collection tools, such as your email opt-in forms, your cookie notices, and your privacy policy, should be updated with consideration to GDPR and e-privacy, because it's a great way for GDPR is not just enforced by complaints. They don't need to have a ton of complaints to come after you like they do here in Canada. CASL is purely complaint-based, whereas in GDPR, if the Data Protection Authority has any reason to believe that you're not compliant with the general data protection regulations, they can open an investigation on you. So they could simply look at your public-facing data collection tools, such as your email opt-in forms or your contact us information or your cookie notices, and decide that you are not compliant and open an investigation. So it's important for you to keep these public-facing things as current as you can. GDPR is role-based. So, for example, if you're a process data for your clients who are data controllers, you must decide on a set of GDPR compliant processes, policies, and procedures that apply to you as a data processor. And you must document those and have them in place so that if you ever have any kind of breach or a series of complaints filed and the data protection authorities want to investigate you as a processor, you have to have your documentation all lined up and ready to produce, including your third-party agreement with that data controller that suggests where your responsibilities end and theirs begins. So another hat that you might wear as a direct marketer, once again, what are your policies and procedures as a direct marketer? So if you're the controller, you must document your policies and procedures around how you process that data, what you do with it, and whether or not you have permission and consent to do so. So on May 25th, 2018, GDPR came into force. We've seen about close to $500 million in fines to date in the first couple months, or the first, 18 months. The fine capability under GDPR is significant. It's up to 4% of your global revenues to a max of 20 million euros. And there's for some violations, it's 2% and up to 10 million. So the fines are significant. Let's look at some individual rights. So you have to document how you're. Let me phrase this a different way. Up until now, you haven't had to know what you know about Derek Lackey. You haven't been able to. You haven't had to. There's been no law that's had you have to provide that. So if Derek Lackey asks you, "What do you know about Derek Lackey?" you would just laugh and go about your business. Under GDPR, you actually must be able to answer that request. The individual rights granted under GDPR are the right to be informed of what you're doing and why you're capturing data, the right of access. I have the right to know what you know about me. The right of rectification. I have the right to correct that. I don't know if any of you have had the opportunity to try to deal with a credit bureau and to change any information that a credit bureau might have on you, but it's nearly impossible. And GDPR grants the individual that right. The right of erasure. So when I learn what you know about me and I don't like how much you know about me, I can ask you to delete everything you know about me, and you must be able to do that. The right to restrict processing. So I might, once I know what you know about me, I might say, okay, you're okay to email me, but don't profile me. And I have the right to restrict what processing you do with my data. And I have the right to data portability. And so what that means is, for example, in the insurance business, if I want to go from supplier A to supplier B, supplier A has to be able to provide supplier B, my choice, in a consistent manner. They got to be able to transfer the data that they have. So I can simply tell my old insurance company to transfer my data to the new one, and they must do that. In the current system, they don't play nice with each other. It's a competitive thing, and GDPR has flattened that completely. So if I want to change banks, my current bank has to cooperate with my new bank. The right to object. and again, this goes back to more, it's from what I can understand of the right to object, is kind of like the right to restrict processing. And also the rights related to automated decision-making and profiling. So again, that kind of ties back to restricting processing. If I don't like what you do with my data, I can tell you to stop. So let me tell you and explain why the only answer to a GDPR question is it depends. And when a privacy professional says that, they're not being coy or being stupid, or it really does depend, and it depends on a lot of factors. So let's look at Article 6. Article 6 is the lawful basis for processing that I spoke about earlier. So there's two questions to ask. Am I a data controller, data processing, and which lawful basis am I claiming to be processing against? So if I'm sending somebody an email, then my lawful basis of processing can consist of really, there are 6 options. You've got consent, you've got contractual and legal obligation, which is more government police. And we also have protect the vital interests of the citizen or in the general public interest. And then the final one is called legitimate interest. This one's the most perplexing but most interesting. Processing is necessary for the purposes of the legitimate interest pursued by the controller or by a third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject. So there's a balancing process that you must go through. There actually is a legitimate interest assessment tool available to say, all right, I'm sending this person an email based on my legitimate interest. It's in the best interest of my business. And it doesn't really override their rights and freedoms. It's maybe like a mosquito as opposed to a swarm. So I'm just going to claim legitimate interest and go ahead and send that email. So that's the kind of process you have to go through under GDPR. So if we can, we'll talk about the 3 that are available to us. So the 3 options for the private sector. So I assume I'm talking, mainly here to private enterprise in this conversation. So the data subject is given consent to the processing of his or her personal data for one or more specific purposes. The EU and GDPR gets a lot more detailed. So we recommend to our clients to use preference centers. It's pretty simple because it really empowers the consumer to go in and say, all right, in the area of communicating with me, here are my options. And it's a series of statements, and I say yes, no to each of them. And here is how you do all your data profiling on me, and I say yes, no to all of the statements. And then here is the cookie permissions, and I say yes or no to all the. That is the ideal, because at any moment in time, you're actually empowering the consumer with turning their consents off and on, and informing your systems. A good privacy or a good preference center will hook into everywhere you keep data in your organization. So in other words, when somebody changes their email preference, your email service provider will be notified. The second tool, lawful basis of processing available to a company, is contractual. So if you have now, this is tempting to throw everything in and say, oh, that's just part of our contract. But it actually has to be required in the fulfillment of the contract in order to fall into this. So don't think that the contractual is a catch-all for all existing customers and everything. It's not. I would look to contractual first, legitimate interest second, and then consent as my third option. Consent is hard to get. So, and it's even harder to prove given our current processes. Unless you change your processes to track and record consent properly, it's a lot more difficult to prove. But the main thing is it's harder to get. Until the consumers start trusting corporations with their data, I believe consent should remain to be the third choice. Contractual is obviously the best. Legitimate interest is the next best, and then consent would be my third option. Let's talk about a little more about that. While it's clear and stated, and you can record it, the individuals tend to be more engaged with your brand when you use consent, and the possibility of a fine is significantly reduced. The disadvantages, of course, is it's often difficult and expensive to obtain. There's a reasonable time limit must be selected. In Canada, when somebody gives you express consent to email them, it's for life or until they unsubscribe. In Europe, a reasonable time frame must be selected. So I use this example frequently. The car buying cycle is a 5-year time frame for most car dealers around the world. So a reasonable time frame for keeping somebody's information when they've bought a car might be 5 years, but you have to be able to make your case. And then quantity takes a backseat to quality when list building. I believe that should be the way it is in all electronic communication. Is quantity's been greatly overrated. I've seen people brag about having 1 million people on their email list, and only 17% of them are opening in a typical year, and they're kidding themselves. They think they have 1 million, but they really only have 170,000 are actually engaging with them. And I suggest to you that you look at your engagement online more than your quantity. Contractual, the advantages, reasonable processing is applied in order to fulfill the contract. Lists will tend to be larger, and you can kind of treat it as a subscription. The disadvantages is you can't make this stuff up. You can't have it be a catch-all. Terms and conditions can be challenged based on the necessity to fulfill the contract. So the Data Protection Authority could still fine you, even though you're claiming contractual lawful basis of processing, if they deem that what you did with the data had nothing to do with the fulfillment of the contract. So just be clear, it's not a panacea and a catch-all. And it does not include prospects. Legitimate interest is the most interesting, but also it's a little bit like Phil Mickelson was described by David Faraday as a drunk on the edge of a cliff. Legitimate interest is a little bit like that drunk on the edge of the cliff. We're understanding it more and more as fines come out and interpretations come out, but it covers a wide interpretation, and it allows most B2B marketers to simply carry on doing business. Most business in Europe was based on an opt-out basis. You must always give the person you're communicating with the ability to opt out, and that's always been so. Under Germany got a little tougher. Germany was the first to do a strong consent basis, but most European countries are on what we call an opt-out basis. Is I can send you stuff, and if you ask to be opt-out, I must do so. The disadvantages is it applies to light data marketing and an interpretation that can be challenged. So you could you could set up your GDPR policy on one way of doing things and find out after being investigated that they're not going to accept those interpretations. And legitimate interest is such a ill-defined at this stage pool of data that a lot of companies are betting the farm on it, but they could have to backtrack and really change all of their systems. So it's even the lawyers continue 18 months in to debate this one. So the interpretation that can be challenged. Now, I would suggest to you that you would not be fined, but you might have to change your practices going forward if the Data Protection Authority deemed that your claim of legitimate interest was not legitimate. This is a quote from a friend of mine, Phil Lee, who is a partner in privacy and security information for Fieldfisher, one of the leading privacy law firms in the world. He said, much of the direct marketing that business sends today is sent lawfully on the basis of opt-out, not opt-in, which is what I was just talking about. In these instances, there's no legal requirement for these businesses to seek fresh consents under GDPR because their marketing was never based on consent, opt-in the first place. So, still lots of controversy around legitimate interest, and this was Phil's take at you can use legitimate interest to do your marketing to Europe. So once again, and not being cagey and evasive, the only honest answer to most questions about GDPR is it depends. And that's really why you have to have a conversation with somebody who understands it, and you have to contextualize it around the issue you're talking about. So if you're talking in regards to how we email people, then it depends. Are you the data controller or are you the data processor? And it depends what lawful basis you're claiming. Now we can start to get into it. So to that end, if you have any questions, our team will happily do a 1-hour Zoom call with your team and answer any of the questions that we can, particularly the ones where your team's hair is on fire, where they're really concerned that they're not in line with GDPR and they just want to try to understand. And why you can't just publish here are the rules is because it truly does depend on the situation. So in a conversation with your team, we can understand the context and the situation, and we can provide some guidance as to what you can and can't do based on GDPR. So now you might understand why it's causing such a ripple in the marketplace. It is deep, it is wide, and the fines are significant. So it is something, if you're doing business with Europeans or in Europe, you should pay attention to. So I thank you very much. Bashir, if there are any questions that anybody has or that you have, I'd be happy to answer them.
To the question, the thing this is quite interesting is that it applies both to US and Canada, right?
Absolutely.
And so that's going to be helpful for our folks in the US too, because of the fact that they are doing business and the e-privacy is the one you were referring to where all these things are going to be combined, correct?
Yeah, e-privacy is more the what I would call the communication side. So if GDPR is the equivalent to PIPEDA,
right,
then e-privacy is the equivalent to CASL. So
okay.
It dictates how you can use electronic communication. In fact, e-privacy in Europe even dictates how you can do direct mail. They actually have a do not mail list in Europe. And if you send somebody direct mail by postal service and they're on that list and you haven't scrubbed against that list, you will be fined. And the ICO in the UK has been very busy finding companies for activities like that. There's a do not call list and there's a do not mail list. And if you don't scrub against it before you market against, if you use those methods of marketing, you will be fined.
The fine that you were talking about am I correct? Facebook was fined pretty heavily under this?
Yes, Facebook and Google have both been fined. Actually, Facebook not as much. Google's been fined heavily, $50 million. Facebook has they've had their knuckles wrapped a couple times, but the Irish Data Protection Authority is the one who would fine Facebook because that's where they're located, and the Irish Data Protection Authority has been one of the slowest to fine. And I believe that the reason is quite simple. The big tech companies who are based in Ireland, like Google and Facebook and Apple, their legal departments are tying up the Data Protection Authority with all kinds of legal loopholes and contesting things so that the investigations are not able to progress at the speed that the Data Protection Authority would like to see them move at. Because the big tech companies' lawyers are slowing them down.
Are you aware of any? Sorry, go ahead.
I think there's 100 as of this morning. I just read from the Irish Data Protection Authority. There are 127 investigations going on right now in Ireland.
Wow.
And some of them will come. It would be reasonable to expect an investigation of this nature, of this complexity, to go a year and a half. So that it's gone now even close to 2 years. It's May, so I guess it's close to 2 years. Is not surprising, but I think when the Irish start fining, they're gonna be dropping like flies. But I truly believe that the legal departments of the big tech companies are playing all kinds of games with them.
So Derek, if you're a company like, other than Facebook and Google, which we know have deep pockets and are fighting it, or finding some loopholes to keep going, you at minimum, even if you didn't pay a 50 million fine, you would actually be stung pretty badly with the legal bills of trying to fight that.
Yes, many of the fines we're seeing are like in the 200 and 300 and $200 million range, which for the average company is going to be worth fighting. But the privacy lawyers are reticent because they're saying there's no way the EU Parliament is going to upend their own law that they put so much effort into putting in place to protect their citizens. There's no way they're going to listen to Google's argument. They're going to go, it's like Google's fighting their $50 million fine, but there's no way they're going to win it because the EU Parliament can't afford to undermine the entire GDPR by allowing them to win it. And I've looked at in depth in the charges, and there's no way around it. Google is doing what they charged them. Right?
It's going to get very interesting.
And therein lies the problem. Pre-GDPR, we were able to do whatever the hell we wanted with people's data. Post-GDPR, we're not. We're not. We are custodians of that data, and we must use it respectfully and for a limited time and for express consent purposes. No longer can you take my data and dole it out to 1,000 advertisers who want to bid on me, and you're going to give them all my data so they can determine whether they're going to bid on whether to put their ad in front of me. The whole online advertising business is in jeopardy of being like a Jenga, the wrong piece being pulled out. Because if you understand how it works, real-time bidding and online buying of digital advertising, you realize that no person ever gave their consent for their data to be used that way. And yet, here we are.
Leon's asking, what is the impact of GDPR on censorship?
It has no. I don't think it has an impact on censorship. That's freedom of speech and all of that. It simply says that you cannot do with people's data what you used to be able to do. So it's not really about censorship. It's about the individual's right to privacy and the individual's right to be able to determine, like, if I'm okay with you doing all the crap you do with my data, then rock on, right?
Yeah. That brings up a couple of very interesting questions. Number one would be, if you are sitting in UK or Ireland and you are saying, and by December we're going to be out of EU. But my understanding is that Ireland is saying, no, we're going to continue with GDPR, right?
Actually, so is the UK. So the UK have adopted GDPR. They want adequacy from the EU. And the best way is to say, when you bought into GDPR, so did we. So all of the Digital Privacy Act that the UK has implemented is based on GDPR. So it's going to make no difference. EU, UK, Ireland, it's going to make no difference. They're all still under GDPR.
So some people who are not compliant and thinking, I'll be okay by end of the year, is not going to be so, because you will
It's not going to be so. Yeah.
Fantastic. Are you aware of any Canadian companies that have been either warned or fined so far?
The very first fine under GDPR was Aggregate IQ out of Victoria, BC.
Oh, okay.
And they were Cambridge Analytica's partner in misusing Facebook's data, and they were the very first ones fined.
That is actually very interesting. So nobody should. Now you're sitting on the laurels here in Canada.
Oh no. Yeah, if you're managing EU data and you haven't paid attention to GDPR to date, you really should at least get the fundamentals I talked about in place. Lawful basis of processing, whether or not we're a data controller, third-party agreements, cross-border data transfers. You should at least have policies in those broad areas. Even if you're not going to, there's 99 articles and 173 recitals within the law of GDPR. So you may not go full on, but you need to at least take care of the ones that I talked about in this presentation.
That's actually very good. You know, you referred to something which was quite interesting. You talk about data as being an asset liability. Something I've been saying for credit card data and PCI for one good reason, that you accept a credit card, you store the data. Once a settlement occurs, when you've been paid for, the merchant gets paid, the person who used the credit card has been charged. To keep that data is absolutely ridiculous, because there is no other benefit other than a potential liability. So they would tell me that, oh no, what happens if there's chargeback? I said, you don't start the chargeback, the client does. The client says, I didn't buy this thing, or I'm returning it, or whatever. They bring the card number, you get the information. And Visa has that information anyway. So you don't need that. So why are you storing it? And the mental block, or the culture, or the fact that we've stored everything, because even the accounting people would keep it because they say, well, I need it for reconciliation. And I would say, no, you don't reconcile the credit card numbers. You reconcile dollars and cents. So, so it's very interesting that it's liable. So if you go broader, invoices, other data that you talk about, the same thing as you referred to quite effectively applies, really, that you better not store information you can't protect and don't need, right?
Actually, I have a client that will remain unnamed, but they're a global retailer.
Okay.
And they sell their merchandise in just about all countries. And they're about 21 years old. And when we engaged with them to put their GDPR program in place, I asked, how long do you keep data? And they looked at me like I had horns. And they said, forever. They did not have a data deletion policy. So the very first transactions they did 21 years ago, they still have a copy of that data. Now, all government, even CRA, only requires you to keep it for 7 years.
Right.
So at the very least, your data should be cleaned every 7 years in Canada.
Right.
Right?
Yeah, absolutely.
But I equate data being thrown out to. Have you ever tried to throw a CD out?
I cut it up before.
You grab the CD. Well, we do now, but 5 years ago or 10 years ago, you would have never dreamed of throwing a CD in the garbage.
No.
Because there might be something on that, right? There was just something. You would throw paper out all day long, but you wouldn't throw that CD out. And there's some of that mentality attached to data. Is what if we need that? We might need that sometime. So they never throw it out. And I think it's a big mistake that a lot of companies make with their data because it actually pollutes. It actually pollutes the valuable data that you have when you keep old and unclean data in the system. So I think by making sure that you have a data minimization strategy, only collect what we need, only keep it as long as we need to, your data is going to be cleaner and more relevant to the people you're dealing with.
That's right. Leon commented shred it, which is what I do on a lot of things here.
Exactly.
And my wife says, why are you shredding it? Just take out the name and stuff. And I said, no. We've seen actually a boarding pass with just a couple of information actually picked up, and the entire background of that person you can zero into through so much stuff that's, all the SIN numbers or SSN, social security numbers are on the web in the US, right?
Yeah.
So you can pick up some information, go backdoor and find out all sorts of stuff. So that's correct. That's actually a good. No, this is actually very interesting. What you covered thoroughly here, even if it's high level, to say, listen, guys, you need to dig into this a little more and understand your responsibilities, because they've got away in the past by saying, but we outsourced it. And what you just proved, and what PCI and many other standards say, you can outsource work, you do not outsource responsibility.
Correct.
Right. So that
and up until now, under the General Data Protection Directive, which has been in place for 20 years in Europe, and the directive simply meant here's a set of recommended guidelines to make your local country rules on, right?
Right.
But under that, it really was okay to do certain things, and since they made it the regulations and have the power to enforce, and they are enforcing it aggressively, I believe I did the math not 2 weeks ago. There were 227 fines for a total of almost $500 million, 466 million.
Well,
under GDPR. So I'm reading in this morning's New York Times that it's not that GDPR is in danger of failing because of lack of enforcement. And I'm like, bullshit. If there's a lack of enforcement, there's a lack of enforcement against the big guys. But that's only because it takes longer, and the lawyers are really good at stalling. That the average businesses and the fines that they have given out, and they are mainly to average businesses if you look them up. They're to police departments for making public a rape file. Okay, here's your fine. Like I saw a UK police department get fined £130,000 by the ICO because they revealed a woman's rape file publicly. They had no right to do that, right?
That's right. Yeah, it's a very similar thing in this because of the COVID crisis. BC gave an exemption for data to flow from BC into US and back and forth. I think up to July. Do you have any views on that?
Yes, I do. There's a balance here with trying to do track and trace, and you can track and trace without revealing people's personal identity.
Right.
And Google and Apple have proven that in their model. It has nothing to do with personal identity. It's got to do with the owner of this phone was near somebody who contacted you should have yourself checked. So that doesn't mean they know Derek Lackey. They just go, the owner of that device has sent a notification saying you should get checked because you were in the vicinity of somebody who tested positively. So I don't think you have to give up personal information in order to cooperate and do your utmost to help shut down COVID-19. And there's quite a controversy on it right now. In fact, I just published yesterday on my Blazon Online an interview with several people on this whole controversy of COVID-19 and privacy. So there's a good YouTube session. It's a little over an hour long, and they talk about this very thing.
Well, we will pick it up. The reason when I heard that, I was on a call with Dr. Ann Kevorkian. We were talking about this, and I was equally horrified, and I was very pleased that she was too, because we have seen exemption become the rule in period of time because nobody goes back to really look at it. And here's the reason why. On the cell phones, really your SIM card and all that run on the IEMI. That's the key part, right?
Yep.
So they could actually tell you if this IEMI number was there and just send a message that, like you said, that you better get checked out because you were in contact with the people who have now tested positive. So why would you have to give the name and address or anything like that? That made no sense to me. And I think it may have been a knee-jerk reaction quickly to, deal with the problem. But
yes.
Hopefully they will sit back and saying, we better pull this back. Because once the data is given out, you don't have it back, right?
Well, it's a little bit like, I think income tax was a temporary measure in World War, right? With the First World War?
Yes, correct.
Yeah, and look where that's gotten us, right?
That's right.
So I agree. I don't think we have to be difficult as privacy professionals, but I think we have to be professional and responsible, which defines Ann Kevorkian. She will always take the high road and what's best for the person. One thing I've always loved about her principles of privacy by design,
right,
is they are designed. The fundamental one is how about setting no as the default instead of yes?
Right, exactly.
Right?
Yeah, absolutely. In real time, we are looking at a situation with Zoom. Zoom, I've been using for 2+ years, maybe more. Very good software, easy to use, good company from everything we know. Challenge has been that, they may not have thought about the security, right? They didn't, right? So what has now happened is that we have a software out there. Now they are running back to try and see if they can correct some of the problems, right? And when it would be a hell of a lot cheaper to have thought through this and kind of worked on it before rather than after the fact, which we see quite a bit of going on. So I think, Derek, you have done a fabulous job once again on this
thank you.
on GDPR as well. We will make it available, but we will also seek questions from people, as you have quite rightly already said that in the presentation. And I want to thank you again, and I will be in touch in the afternoon.
My pleasure.
Thank you very much. I really appreciate that.
My pleasure. Thank you.
Take care. Bye.